Now, for those of you who have been with us in the past, you know that we've typically tried to go through legislation with a bit of a worldview flavor to it, so you understand the worldview behind legislation, particularly legislation that we're working on. But I wanted to say tonight that the gravity of the situation, to be honest, that we're confronted with really requires us to be more intentional in talking about the worldview that we're dealing with than we've been in the past. And if we don't do that, to be honest, some of the legislation we'll be talking about won't make sense, or you won't appreciate why it's important, because on its face it might not look too glamorous. So with that as a little bit of background, I want to tell you that tonight we're going to do this. We're going to look at the worldview with which we're confronted. We're going to look at the outworking of that worldview in Tennessee. So we want to give you the big picture, then we want to show you what the picture looks like in Tennessee, which will then make the legislation that we're going to be talking about make more sense. Now, all four of the areas in which our organization is most interested, which is marriage, family, life, and religious liberty, have all been impacted by a little noticed, to be honest, little appreciated, revolutionary change in the worldview in the law. Most of these changes came about way before I was born, but I've begun to understand them, and it's important that you understand them because it's changing everything. The very nature of law itself has changed over the last 80 years, and that change in the nature and understanding of what law is now being used to change what it means to be human. It's changing our understanding of what it means to be human. And you have to appreciate that the change in those two things will necessarily change everything else. If you don't remember any of the details that I give you tonight, or Will and I give you tonight, hopefully you'll remember this image that I'm about to give you. I owe this analogy to a friend of mine, Jeff Schaefer with Alliance Defending Freedom, who in speaking with me several months ago, used this analogy, and I think it's appropriate. So here is the picture that I want to give you, and I hope you can see it well enough in here and online. But this is the Lifeway building and the Draper Tower. So assume that you're at work a couple of weeks ago. You hear this loud noise. You don't really think anything about it. A few minutes later, you feel a little bit of a loss of equilibrium, but you just keep plugging away business as usual. And then this is what you experience sitting safely tucked up in your office on the far right-hand corner of the building. I hope you get that picture in your mind. You see, you could be in one part of the building, hear the noise, a moment later feel the rumble and think nothing's really taking place. I'm going to go about business as usual, and the next thing you know, you're buried in concrete and steel. And that's what's happening in our country and in our state, and I'll show you how it is happening and why it's happening. But I hope that picture will stay with you. Because no matter how safe you feel being in a state with supermajorities of Republicans who profess to be Christians, and Republicans in every branch of the government being the majority, including the Attorney General's office, you are not safe. So let's start with the change in the understanding of what's going on in the law. There used to be this old view, I call it, that there existed this thing called pre-political, pre-governmental law. It was actually referred to as natural law, and most of y'all have probably heard that term. Christians have an understanding of natural law, but it's not been limited to a Christian understanding. Even Cicero, between the period of 51 to 54 BC, wrote on the Republic. And he talked about the fact that there is a natural law that applies to all people in all places at all times. And that natural law was the foundation for what we know of as the common law. Now, one of the great proponents of the common law in our country was a jurist by the name of Joseph Story. He was the youngest man ever nominated to the United States Supreme Court. He was a constitutional law professor at Harvard University. He wrote the first commentary on the Constitution of the United States. And so it's not surprising that we find Joseph Story writing probably the seminal case in constitutional law history on the issue of common law. It's a case called Swift v. Tyson. It was written in 1842. And this is what he said. The law respecting negotiable instruments. Now, for those of you who aren't business savvy, negotiable instruments would be things like checks, promissory notes, bills of lading, warehousing receipts, things you would use in the stream of commerce, paper you would use in the stream of commerce. He said, and it may be truly declared in the language, notice, of Cicero, adopted by Lord Mansfield, who was an English jurist, to be in great measure not the law of a single country, but of the commercial world. There shall not be, and here he begins to quote in Latin, and I translated it for you because my Latin's a little rusty, perhaps yours isn't, but this is quoting Cicero, or paraphrasing him. He says, there shall not be one law at Rome and another at Athens, not one law and now another hereafter, but also among all the races and all the time one and the same law. So the idea is that there is a law that exists over the whole of the planet that we did not create that applies to certain commercial transactions. The only law is not the positive enactments of a legislative body. There is a preceding law. But after Darwin's evolutionary theory came out in 1859 and began to work its way into other fields, including law, one of the first places was Harvard, the notion that there existed a pre-political, transcendent, natural law established by a creator had to go, because Darwin got rid of the creator. And so in 1938, the Supreme Court finally jettisoned the idea of Swift v. Tyson, articulated by Mr. Story in a case called Erie Railroad versus Tompkins. It's a case that every lawyer reads and studies. I read it. But to be honest, nobody explained the worldview to me that was hidden in that case. And it is applying now, not just across the nation, but particularly to Tennessee, and is being advocated by our governor, by an increasing number of our legislators, and by our attorney general, and most likely, they don't even realize they're doing it. And here's what the court said in Erie Railroad. The fallacy underlying the rule declared in Swift v. Tyson, that's the case we just quoted. It says there's a common law that applies to all people, all places, all over the world. It's not just coming from the legislature. It says that doctrine rests on the assumption that there's a transcendental body of law outside of any particular state, but obligatory within it, unless and until changed by a statute. The federal courts have the power to use their judgment as to what the rules of common law are. So there you see this notion of common law. Common law is rooted in the notion of the transcendent. And they're saying there isn't any transcendent thing out there. And notice what he says, but law in the sense in which courts speak of it today does not exist without some definite authority behind it. Now we have to appreciate what the court is saying there. There can be no natural law. There really can't be any transcendent common law because there's nothing definite behind it. Now you and I would say, well, sure there is. There's God. But see, we've jettisoned that notion in the law. Or at least we've jettisoned the notion that that law is definite enough. Why? Because after Darwin, we began to question the authority of the Scriptures, did we not? Can you remember a famous case in Tennessee in which the authority of the Scriptures was put at issue in 1925, 13 years before Erie Railroad? Yeah, the Scopes trial. So we can't have this idea. How would we know this law if there is even a God behind it? But let's go on to what the court next said. The common law, so far as it is enforced in a state, is not the common law generally. See, that was the old idea. There's a common law that applies everywhere. So no. It's just the common law of the state existing by the authority of the state without regard to what it might have been in England or anywhere else. Look at this statement. The authority, and the only authority, is the state. Now, for those of you who attended our Restoring the Vision, and by the way, we'll have another Restoring the Vision May the 5th here in Nashville, and let me encourage you to come if you haven't, or come back if you need to brush up on it. But if there's nothing transcendent, then law has to be just here. There's no place for any other source of law. And so the court says that therefore, the voice adopted by the state as to what the common law is should utter the last word. Now there's both good and bad in this statement. Let me note here, the bad perspective, it's a clear statement by the Supreme Court that there's no authority when it comes to law apart from the state. Okay, there are no transcendent inalienable rights, at least not at the federal level. If you want to know why the court has to find magical language in the Constitution to create a right, that's why. There can't be any other source of a right. So it has to come from the authority of the state or the government, and the Constitution serves that purpose. But now you understand why we have to have a living Constitution. Because if you're tied down to the words that are in the Constitution, you can't create new rights. And we've already said you can't have rights in a transcendent source, so we have to breathe life into the Constitution to bring in rights, and we root them in the Constitution, and that's what's going on in our court system. And why? What we've done is you don't abolish the transcendent, you make the Supreme Court transcendent. They become God. Now here's the good part. It's a foundation for hope in our state, and that is that the Erie court says that it's none of our business to tell a state what its common law is. Common law of contracts or negotiable instruments or torts or whatever it might be, even marriage, it can be the common law of Tennessee, and Kentucky's could be different. And we have no business telling you what your common law is. And that's good. Because here's what the Supreme Court has said in connection with family law. And now we're going to begin to apply this to our specific areas of interest. The Supreme Court in 1877, now keep in mind, this is not too long after the Swift v. Tyson case, before Erie Railroad, they said this is based on the old view of law, that informal marriage by contract per verba de presente. Those of you who are Latin scholars are probably enjoying this evening, but I put the translation down on the bottom, which is words in the present. Informal marriage by contract by words of the present constitutes a marriage at common law. There can be no doubt. Marriage is everywhere regarded as a civil contract. Statutes in many of the states, it's true, regulate the mode of entering into it. Here's how you give expression to that. And notice what the court said. They do not confer the right. Why? Because it exists apart from the government. It precedes the government. It's grounded in a law that precedes the government. And you have that right. Now, what does that mean for us? Here's what it means. If our state officials are willing to consider getting out of the business of creating government licensed marriages, saying to you, you can't get married without my permission. Now, when you think about that, that does sound bad, doesn't it? I remember when my dad remarried after my mother passed away, and the minister said, let's go back and sign your license. And he said, what license? You had to have a license. Why did I have to get permission to get married? You know, that's what happens when you're older, right? You forget. I got to get the state's permission to get married. Well, if we got out of that and said we're not going to license marriages anymore, but we're going to allow a man and a woman to exercise the God-given common law right to marry, and we will provide them a means by which they can file public notice that they've entered into that marriage, then we have rooted marriage outside the grip of the civil government and outside the grip of the Supreme Court. You see what I'm saying? We've rooted it in something other than the government. But we have an opportunity, a way to restore marriage in Tennessee if we're willing to do so. Now, what I want us to see in the next few minutes is that this rejection of the transcendent has been working its way into our marriage law and into our life issues for the last 50 years. In other words, Obergefell was not as big a groundbreaking decision as you might have thought it was. Okay? So I want to bring to your attention this case in 1965. The fruit of Erie Railroad began to show up, the rejection of the transcendent in family law in 1965. That case involved a state law governing the distribution of contraceptive devices to married couples, and the court struck it down. Probably a silly law, but they did. But in 1972, just 7 years later, the court explained what it did in Griswold. That time it was in connection with contraceptive devices being given to unmarried women. And here is what the court in 1972 said we did in 1965. Notice the worldview here. The marital couple is not an independent entity with a mind and heart of its own, but an association of two individuals, each with a separate intellect and emotional makeup. If the right of privacy means anything, it's the right of the individual, married or single, to be free from unwarranted government intrusion into matters so fundamentally affecting the person as the decision whether to bear or beget a child. Now let me interpret that for you. In other words, what the court is saying, when you deny the transcendent, there are no basis for transcendent realities. Doesn't exist, right? What does that mean when it comes to marriage? It means there's no real thing called marriage. Did you notice what they said? When a man and a woman come together, they don't create some separate entity. There's nothing that emerges from it. It's not that they go from a man and a woman into becoming one flesh, and they therefore have certain rights with respect to one another and duties with respect to each other. They're just two separate individuals, always remaining separate, just associated together. Now I confess, I didn't pick up on that, but I think I was 7 at the time. So I hold myself unaccountable. But if there's nothing transcendent, there's also can be no sanctity of marriage. It just can't be. Theologically, philosophically. So marriage only has the meaning that we ascribe to it. But I want you to appreciate this. Religion is a subjective issue now. There's no reality to it. There's nothing definite to it, right? We've already talked about that. So it can't be a claim to truth, which undermines any pre-political, pre-governmental right to religious liberty. You want to know why we're struggling with religious liberty? Because there is no right to religious liberty outside the civil government, because there can't be. There's nothing transcendent. We just have to fight for our elbow room. And because the only power is the state decides what part of your religion is okay and what part's not. And most of the time, we're fighting on the wrong grounds, letting them to define the grounds on which we get to defend our right to religious liberty. If we are unwilling to assert that there is any transcendent pre-political law, we're sunk. You're just sitting over here working in the Draper Tower thinking everything's fine and there's a lot of noise going on, but it's collapsing. So that's why it would be accurate to say that Obergefell didn't really introduce anything new, philosophically, about marriage at the constitutional level. It's just a creation of the state. Not a recognition by the state of any transcendent truth about the nature of marriage. So what Obergefell really did was it just extended the deconstruction of marriage as rooted in a transcendent reality by denying the male-female element. Where did that come from? We don't like that, right? That's all they did. But here is what is new about Obergefell that, to be honest, we haven't picked up on. We think, okay, that's marriage. We lost that. Let's move on. Nothing new. That's what most of our politicians are saying. It's where most of our churches are, most of our Christians are. We lost. Well, understand what they did do new is humanity has now been redefined in androgynous terms for the purpose of marriage. As Jeff Schaefer said to me a few weeks ago, he said, everybody who gets married after Obergefell has a same-sex marriage. It may be that your marriage has a man and a woman in it, but by definition, the only kind of marriage we have is one that has no sex in it. So we all have that kind of marriage now. Okay? The last logical impediment to constitutionalizing polygamy and polyandry is removed. It's just an association of individuals who are sexless. So there's no reason to have a male or female. Have two males, have two females, well, have three. Have some combination of them, you know, just like when you go get donuts. So this Obergefell decision is not just about same-sex marriage. And this androgynous humanity, understanding of man and woman, has poisonous fruit. Because all that flows from marriage now has to be redefined. It makes sense, doesn't it? If marriage is the definition to which all of our other laws regarding the family are based, when you change the definition of marriage, you change all the other laws. You have to. So, here's what's going to happen. Parentage, mother and father, must be redefined. Since Obergefell, noted law professors began writing, saying that being a parent is no longer related to biology. It relates to your intention to be a parent and the functions you carry out, and whether you carry out the functions that the state deems worthy to designate you as a parent. So appreciate, you must have essentially become a licensee as a parent. There's no transcendent grounding for parental rights. It's gone. Can't have it. There's nothing transcendent. Artificial creation of children is going to be required. Because marriage is sterile, but we got to have the fruit of marriage. So children become more like commodities. Things to be created to meet the needs of adults. And that philosophy is going to have a tremendous impact ultimately on the question of the sanctity of human life, not only because we've lost the possibility of sanctity with the loss of transcendent, but we don't know what it means to be human anymore either. So if you don't care about marriage, but you care about your rights as a parent, if you don't care about marriage, but you care about the life issue, you need to care about marriage. And if you don't understand what's going on. And most of us don't. Now, how's it working out in Tennessee? Here's how it's working out in Tennessee. There's a case called Witt v. Witt in Knoxville. We were involved in this lawsuit. And here was the question. What does the word husband mean? Now, I bet if I ask all of you, you look relatively intelligent, you would know what a husband is. Am I a husband? No. Would I ever? I mean, yes. Excuse me. Yeah, that confused you. See, you weren't paying attention. I didn't see anybody laugh until I caught myself. But here's the statute involved. It involved two women. A child born to a married woman as a result of artificial insemination with the consent of the married woman's husband is deemed to be the legitimate child of the husband and the wife. And the question is, well, what's a husband? And with the urging of the Attorney General, the court in Knoxville said, well, a husband can be a wife. We have another lawsuit going on in Bradley County. It's over our marriage license law called Green v. Simpson. And here's the relevant language in the statute. It says that licenses can only be issued to a male and female contracting parties. You know what the issue in the case is? What is a male and a female? Now that sounds silly, doesn't it? But the Attorney General says, no, the word male can include a female. Now how does he do this? Now, I'm not saying anything, and I know he's probably still watching unless he got tired, but I'm not saying anything here about our Attorney General that I haven't said in open court and in briefs. Our State Attorney General's office, not him personally, but his minions who work for him, who are advocating in these lawsuits, here's what the question is. In their briefs, they start using this. Notice, these statutes invoke gender-specific language. Notice that. Right off the bat, the Attorney General's office has embraced the modern use of the word gender, which is being used as a subjective psychological grounding of psychology rather than a biological reality. We don't want to use the word male and female and words associated with that. We're going to substitute the concept of gender. So how do we get to the idea that a male includes a female and a female includes a male? Well, he goes to a statute that says this. This is the title of the statute. It's in the general construction provisions of our code. And there's a section that deals with how do you treat the tense of verbs in statutes, and how do you treat gender, and how do you treat the number of words. So section 1 says that the past tense can include the present tense and vice versa, if it's not contrary to the intent of the statute. So we don't have to go through saying everything multiple ways. The last part, number of words, says, oh, the singular can include the plural and vice versa. So we don't have to go through saying he, so we don't have to go through saying person or persons. You get what we're talking about here? Okay. But the middle part, here's what it says. Words importing the masculine gender include the feminine and the neuter, except when the contrary intention is manifest. Now, I would say that the word male and female implies that there's a male and then there's something different from that called a female. There's so many things wrong with using this statute to interpret the word male to mean a female. But see, he says, well, see, words importing the masculine, male, can include the feminine. It's kind of like, well, that's correct. But now you have female and female. So all we can have is lesbian marriages. It doesn't say and vice versa, does it? And then I said this, and I confess, I was being a little bit of a smart aleck. My wife would forgive me, I hope. As I said, but if you want to know whether this is talking about biology or talking about grammar, ask yourself, when this was codified in 1858, what did they mean by neuter? Did the General Assembly, were they concerned in 1858 that if we use the word male in a statute, we might leave out the man who's been castrated, and he's a eunuch. He's been neutered. So we don't want to use the word male and leave out the eunuch, right? So we got to put the word neuter in there. Or we were afraid we'd use the word husband and we meant that the husband who had been a husband but now can't be because he's been neutered, right? So that's clearly referring to grammar, not biology. Now I want to say one last thing and then I got to end and we'll hand this over to Will. I would agree with our Attorney General that if you give the word male and female its natural meaning, that it means a man and a woman, then our statute is probably unconstitutional. But here's the point constitutionally. If your friends don't care a hoot about same-sex marriage or any of these other issues, when our Attorney General goes into court and says we can take a word that everybody in the room knows means a man, the common dictionary defines as a man, and we're going to say that it means a female so that we can keep a statute constitutional, we are violating the separation of powers, and we were inviting courts to rewrite words. And here's why that's so irritating. Will and I spend our days down on the Hill trying to pass statutes that have words in them. And if I don't know that my word means what everybody in the room thinks it means, then what's the point of passing the statute if somebody can say, oh, well, that doesn't mean that anymore, it means this. And how can I pass a statute in 1995 that refers to male and females only to find out later, when I voted for that statute in 1995, that it means females and females and males and females and females or males, and I didn't use any of those words. What was I supposed to say? This is a serious constitutional crisis being precipitated by our Attorney General and by our courts. And it has to stop.